So today I wanted to talk about the FTC's approach to certain sorts of reverse payment cases in the pharmaceutical sector, sometimes called pay-for-delay cases. And I think we've been concerned about these under particular circumstances, and at least since the Supreme Court's activist decision, which largely agreed with our prior position under their framework, looking at these things under the rule of reason. And we had a commission case decided a couple years ago with impacts where we were sustained in a good opinion last year by the Fifth Circuit. And the central concern is that competitors, an incumbent and an entrant in horizontal space, in the drug space, will make an agreement which at its inception is anti-competitive and diminishes the risk of competition, key competition by generics and by generic entry. And that, as the Supreme Court agreed in Actavis, it's both sort of the structure of these payments, transfers both of money and a valuable consideration from, curiously, the plaintiff to the defendant, and sort of the magnitude of these settlements in relation to things like litigation costs that raise red flags. What's the plaintiff buying with the payoff? Is the plaintiff buying an agreement that, number one, if it comes to fruition, will delay generic competition, and number two, will diminish the risk of additional generic competition and perhaps delay the entry of the second, third, nth generic competitor? And this is an area of great concern because anti-competitive conduct is very costly to consumers, to healthcare, various payers, public and private, and of course, patients. So we've been, very much concerned. All sorts of agreements between pharmaceutical companies may be lawful. We've been very concerned about particular anti-competitive agreements that harm competition, diminish a very real risk of pending generic entry.